the court can evaluate whether the prima facie case is against the accused is exist or not, or require material for trial is exist or not, that can be evaluated. Even court can evaluate whether whatever executive has taken initiative against the accused, whatever story stated by the prosecution is a made-out offense or not, whether it is legally maintainable or not, and whatever the material exists in the charge sheet, whether enough to conduct the trial or not, and for that whether accused has to face the trial or not. So these things can be possible because of the charge, and this is not mechanical, it demands a reasoned judicial scrutiny. So whatever trial court says that these are the accusation against you, and that can be possible when there is judicial scrutiny, and through judicial scrutiny court can ascertain whether prima facie case is exist the accused, whether legally case is maintainable, whether the accused has to face the trial or not. Equally, because of charge, it legally marks the beginning of the trial. No matter who has committed the case, who has investigated the matter, the trial of the case merely begin because of the charge. If there is no charge framed, there won't be trial. This is the importance of the charge. So everything before this is pre-trial process, inquiry process, investigation process, but there won't be trial unless and until charge is framed. Other thing is that because of the charge, it forms the boundaries for the trial. It creates the outline that what should be the business of the court, what should be the role of the prosecution, what should be the role of the defense counsel, what should be the role of the witness, what should be the role of the trial court, what court has to ascertain out of the trial, that can be formed in form of the boundaries because of the charge. So a criminal trial cannot go beyond the charge. Therefore, charge act as a kind of the blueprint of the trial. This is a kind of map given to the prosecution, what prosecution has to be proved. And at the same time, it is a kind of shield available to the accused, that for so and so thing is concerned, accused should not bother. A shield protecting the accused from surprising allegations. So in advance, the accused knows pretty well what thing needs to be defended. So because of the charge, the rights of the accused begin from this stage up to now, at the right from the moment of arrest, then at the time of PCR, MCR, even at the time of the inquiry, at the time of committal of the case, by this or that way, the right of the accused is somewhere ignored. But now, because of the framing of the charge, the accused is told the accusation in open court, and he is asked whether he plead guilt or not. So, trial rights, defense rights, and fair trial guarantee is begin because of the framing of the charge. So, charges show the path to the accused upon which he has to walk. So, whole trial is conducted in accordance with the charges framed. Now, the important question lies with how charge is framed practically on the paper. So, the judges prepare a written document and stating that this is the offense, this is the legal provision, on this date, at that time, at so and so place, and state that in this way it is allegation against you, accusations against you, that you have committed the so-called offense. It is verbally, it is stated to the accused in the open court, and then the whatever things on the paper stated to the judge, stated to the accused by the trial court, and whatever on the paper it is read out in loud, explain in simple language, whatever the vernacular language is, and record the plea of the accused. If generally he deny the accusations, charges alleged against him, so his denial or admission is recorded, and so on. Once the charge practically on paper, once it is framed, then trial formally opened, and from this moment trial begins. So, in each and every case where the trial is conducted, trial commences with the framing of charge. This is the importance on the part of the charge. Now, so far as provisions under BNSS pertaining to the charge consist of section 234 to 237. It contains framing charges, specifying essential details, correcting errors, adjusting charges mid-trial, handling multiple offences and offenders, withdrawing charges where appropriate. Now we are proceeding towards the provisions. Up to now we have discussed the background behind the charge. Got my point? What is importance? What is the charge? Why charge matters? Now we are taking the, stepping in the provisions of the law. Procedure we are now going to switch on. So the first head is the cumulatively the charge. It contains from section 237 to 234 to 247. यामध्ये काय काय आहे? चार्ज फ्रेम करण्याबद्दलची माहिती, चार्जमध्ये नेमकं काय काय असतं, चार्जमध्ये एरर असेल तर त्याची दुरुस्ती कशी, हाऊ चार्ज कॅन बी ॲडजस्टेड when offenses are multiple. Multiple mean sometime preparation is one of the stage of commission of offense. After preparation, second stage is attempt, third stage is commission. Sometime for commission of your offense, two or more than two persons indulge, agreeing to commit. Some does before commission the role performed, some during commission of the offense, and some after the commission. So abatement of offense and commission of offense, so whosoever being part and parcel of the commission of offense, maybe 2%, maybe 3%, maybe more than 3%. So whether they supposed to be joined in one charge or separate charges are to be met against each. Even withdrawal of the charges is also cumulatively the provision under section 234 to 247, it is defined, it is prescribed. Now, form and content of charges, section 234 to 237. What are the content of the charge? Section 234 lays down the essential elements that every charge must contain certain things. One, at the same time, a properly drafted charge ensure the accused clearly understand the accusation so as to prepare a defense. So the key requirement for the statement of the offense is the charge must clearly state the offense for which the accused is being tried. If the law provides a specific name to the offense, then name should be stated, such as theft, robbery, dacoity, extortion, whatever it may be. If there is a title of the offense is, then title must be stated. It may be described by that name alone. So there shall not be any sort of confusion. If it is theft, then supposed to be it is to be stated theft. If suppose there is no specific name is exist, no specific title to the offense is exist, then whatever legal definition is prescribed under BNS or any the substantive criminal law, the definition of the offense or even for commission of a particular offense, the so-called essentials required, the so-called essential ingredients must be included in the charge. So statement of offense contain that the charge must be clearly stated that the offense for which the accused is being to be tried. If specific name of the offense is, then name is to be stated. If no specific name is exist, then definition as well as essential ingredients of the offense is to be stated. Further, not merely stating the name of the offense or definition of the offense or essential elements of the offense, it contain also the provision of law, the so-called law and the so-called provision of the law. It means law and section, the so-called number of the provision of law under which the offense is committed is to be stated. Beside the mention of law and section, it must be stated facts constituting the offense. So the charge must include the facts and legal conditions that constitute the alleged offense, beside the language of the court. So the charge must be written in the language of the court. If there is any pre-conviction exist, so enhanced punishment for the habitual offender, or suppose if the accused has prior conviction that are legally relevant for enhanced sentencing, the fact of conviction in form of the date of the place must be mentioned in the charge. According to section 235, particulars as to time, as to place, and as to person. This section 235 emphasizes that the requirement of specificity. So the accused knows exactly what conduct is being alleged. It includes the time of the offense. The charge must specify when offense taken place or committed. Place of the offense. Charge must state where the offense is occurred. Person against whom it was committed. When relevant, the identity of the victim or the person affected must be mentioned. Even the special rule for criminal breach of trust or misappropriation. When offense involves misappropriation, breach of trust, or dishonest handling of the property, it is not necessary to list each item or exact date. Instead, the charge may mention only the gross amount or general description, provided the period does not exceed 1 year. It means that the charge is concerned, the particular include time, place, and person. At what moment of time offense is committed, at which place the offense is committed, who is the victim of the offense, whether the offense, the kind of the offense is breach of trust or misappropriation of property. There is no need that each and every sorts of property is to be listed. It merely the way through which the criminal breach of trust or misappropriation is committed, that is enough to be stated. But the thing, the commission of the act, if there is a series of action, so within a year, whatever series taken place for commission of offense is to be stated. Section 236, manner of committing the offense. This section requires the prosecution to specify how the offense was committed, when the manner forms an essential component of the charge. It means that merely stating theft is not enough. Merely stating the definition is not enough. Merely stating provision of law is not enough. What is required? The manner through which how offense is committed is relevant. Then it needs to be stated. If an offense involves a particular manner of commission, such as cheating, forgery, or giving false evidence, the specific mode must be included in the charge. For example, in a case of cheating, charge must explain how the deception was carried out. So this ensures the actually fully understand what exact allegation is against him. According to section 237, the interpretation of words in the charge. This section governs how the words used in charge should be read and understood. In such a manner, it should be stated. So the rule of interpretation says that words used in describing an offense in a charge must be interpreted in the sense assigned by the specific law that create that offense. You cannot use your own language. The language should be used of law. So even you can interpret and convey, but whatever we are court is stating, the finally what thing needs to be reached to the accused is in the terms of the sense of law. There cannot be drawn the separate meaning or different meaning, or one cannot infer something different. So precisely it should go. Sometimes the language of the law one cannot understand as such. So you can convey in such a way by using the word, but finally what should be reached? The sense of the law should be reached. The sense of the provision should be reached. One cannot take differently what is expected to the law or to the section 237 to prevent the ambiguity and to ensure the inconsistency with the statutory meaning. Whatever statutory meaning of the particular provision or particular offense, accordingly the words can be used and charge can be stated to the accused, that he shall prepare the defense, he shall do the things necessary for defense of his case. This is the chart containing section 234 to 237. So what 234 says? Content of charge. Content of charge includes stating of offense, mentioning law, mentioning provision, mentioning fact. It should be written in the language of the court. If there is any prior conviction, is to be stated. In accordance with section 235, particulars as to time, place and person must be specified, must be stated. When it was committed, where it was committed, who is the victim. If there is a misappropriation, then describe in which manner misappropriation is committed. In accordance with the section 236, manner of committing offense, charge must state the particular manner when relevant. And so far as 237 is concerned, the interpretation of word. The language of the law sometime one cannot understand easily. So the words can be used, but statutory meaning of the provision of law should be conveyed. What is expected to section 237 of the BNSS. Now we are proceeding towards effect of errors, section 238. Section 238 of the BNSS deals with the legal consequences of errors, omissions or irregularities in the charge. This provision ensures that if it appears there is any minor errors, mistakes, if it is exist in the charge while framed, that cannot invalidate the proceedings unless the error or omission adversely affect the right of the accused, or if adversely prejudices to the accused, then error needs to be rectified. If there is grammatical mistake, what we use the term clerical error, we use the term human error. If there is a human error in the charge frame, it won't adversely affect. But any kind of mistake, any kind of error, if adversely affecting the interest of the accused, right of the accused, or by any means if it is prejudice to the accused, then needs to be rectified, and that can be rectified under section 238. So this provision is basically retaining the philosophy of the earlier law, that is Criminal Procedure Code, the provision, but is now placed within the updated BNSS structure. The general principle behind section 238 is, it says that errors or omissions in the charge do not automatically invalidate the trial unless and until it is mislead to the accused, and unless and until if there is a failure of justice is taken place, then and then Section 238 will come in motion to rectify the errors or omission in the charge. Otherwise, it cannot automatically invalidate the trial. So it means that the procedural objective is fairness, not the technicality. We are not going to look into the technicalities. We are going to look into the fairness. The purpose of correcting the error in the charge, we want fairness. We don't want to look into the technicalities. So, court always focus on whether accused was truly prejudiced because of the error exists in the charge, then court take its course of action to correct the charge. There are basically types of error covered under section 238. There are two kind of mistake or error sometime may cause. One, error in stating the offense. For example, if the offense name is misstated or wrong provision of law is mentioned, sometime errors may occur in particulars, issues like wrong date, incorrect place, mistakenly taken the name of the victims or sometime accused, or omission sometime may cause leaving out certain factual details or legal ingredients, sometime clerical, typographical, in form of spelling mistake, formatting issues. Such mistakes are human errors, and such a mistake cannot vitiate the proceedings unless and until the so-called mistake, so-called confusion, so-called suspicion, so-called dilemma adversely affect the rights of the accused to defend the matter, or when it appears there would be a failure of justice is caused, and therefore for correcting the errors certain tests are applied by the court. So far as failure of justice is concerned, court apply two-part test. Number one, to invalidate the proceeding because of the error in the stating the charge was mislead the accused. So question is put forth, was the accused mislead because of wrongly stated, if there is a error in the charge, did the error prevent the accused from understanding the accusation? Whatever stated by the court, whatever written by the court in the charge result in mislead to the accused in understanding the provision of law, understanding the what kind of accusation, what kind of offense is alleged. Second, because of error in the charge, did it cause a failure of justice? Did the error harm the accused's defense or affect the fairness of the trial? If answer is yes, charge need to be corrected. Proceeding become invalidated if there is no correction of errors. Only in both of the cases, under such circumstances, the error matters and needs to be addressed. What does not amount to a prejudicial error then? Some errors are occurred are considered immaterial. Um, Such as minor date description, 12th March instead of 13th March, slight inaccuracy in location, near the market versus market road. The words are one and the same, slight differences. Small mistake in offense description where essence is clear. Incorrect legal section cited, but facts clearly shows the correct offense. Under such circumstances, there won't be prejudicial error. What adversely affecting? The court presumed that non-material inaccuracies should not derail the trial, shall not vitiate the trial, and therefore the court has to take the necessary initiatives when error need to be addressed, when error required no need to address. So court has power to cure errors. When error is discovered, the court either correct it or alter the charge. So under section 239 of the BNSS, alteration of charges taken place and result in allowing to recall and re-examine the witnesses. So the accused can adequately respond to the corrected charge, whatever the corrected charge is accordingly. Again, evidences and witnesses are recalled and re-examined to the extent of the correction. This ensures the fairness and to prevent the miscarriage of justice. Otherwise, incorrected thing cannot be proceeded. Otherwise, there is no use in correcting the charge. So, the purpose behind section 238 is to prevent the technical acquittal based on minor defect, delay in trial due to correction and inconsequential errors, misuse of procedural loopholes by either side. The goal is to maintain a balance between procedural fairness and efficient judicial justice delivery system. This if there is error in stating the charge, you reduce in writing something and stating other thing. Accused is illiterate. He should know under what provision of law the offense is alleged. He has to prepare a defense. He stated something and he prepared for other thing. Does it mean fair hearing? For conduct of the fair hearing, it is sine qua non. Charge must be stated wisely as such. Whatever reduced in writing in the charge, it should be stated as such. Sometimes the provision, sometimes the legal provision, judge cannot state as such. Sometimes it won't be digestible. The words used under the legal term, that phrase, sometimes accused won't understand. So he can interpret, but while interpreting and while conveying, he should be use the word in such a way that clear cut the sense of the legal provision is to be inculcated. अरे कायद्यातील तरतूद ही आहे आणि तुम्ही सांगताय काहीतरी वेगळं, असं जर होईल तर उद्या डिफेन्स कसा घेईल तो? त्याला हार्डशिप होईल ना. आणि म्हणून द कोर रूल इज दॅट error in charge do not invalidate proceedings unless they must mislead the accused or cause the failure of justice. There are two things. It should adversely affect to the right of the accused, and if there is a failure of justice. If either of one thing is happened, the charge is to be corrected. There is error. Otherwise, there is no need. Wrong legal section, factual inaccuracies, typographical error, omissions, whether accused understood the accusation, whether the defense was prejudiced. So, when court has to correct, when court need not address the correction. Only two things, whether whatever stated is adversely affecting to the accused, whether the failure of justice is caused because of wrongly stating error or quoting. Sometime the accused may get the benefit of doubt and he may be acquitted unnecessarily. So it is failure of justice. He may take the benefit of it. Now, section 239 to 240, alteration of charge. When charge is to be altered, so it means that there is no rule. Once charge is framed as such, the trial is conducted by hook or crook. Once framed, frame forward. No. Charge is framed for this reason, but that does not mean charge won't be altered. Charge can be altered. This provision ensures flexibility while safeguarding the rights of the accused. So, section 239 provides alteration or addition of charge. Section 239 empower the court to alter, mean to change, or even to can add any charge at any time before the trial court pronounce judgment. So, alteration or addition of charge can be taken place only and only before the pronouncement of judgment. It means that it prevents such alteration or such addition of the charge from doing injustice arising from technical error or missing elements in the original charge. So, what kind of power of the court is to alter or add a charge? The court may alter, court may modify, court may add a new charge if it consider such alteration is necessary for complete disposal of the case or for proper adjudication of the so-called case. Alteration is required, addition is required, then necessary addition or alteration can be taken place. Once the so-called alteration or addition is taken place, then the altered or added charge must be read over, must be explained to the accused, ensuring they understand the new accusation, altered accusation or added accusation needs to be communicated. Once the altered or added charge is communicated to the accused, what procedure after alteration is depend on whether prejudice will be caused to the accused or not. If it is caused or if it is not caused. If no prejudice is caused, then the court has to proceed with the trial. It means if the alteration does not prejudice the accused, the trial may continue normally. And if the charges are substantial and may affect the defense, the court has to start the fresh trial and court order for conduct of the fresh trial to the extent of alteration, to the extent of addition. If it is required, then court has to order for fresh trial. Otherwise, the court has to proceed with the so-called normal trial. Sometime the court may grant time to the accused and prosecution to adjust the new changes for ensuring the fairness, and for doing so the court may sometime postpone or adjourn the trial. Either court proceed with the same trial, or court may order for separate trial to the extent of the added and altered charges, or sometime court may postpone the trial and give a specific time to the prosecution and to the accused to adjust with the new change or new charge. The purpose is to ensure fairness. Now, requirement of prior sanction when applicable. If the altered charge requires a government sanction, the trial must be stayed until the sanction is obtained. So far as if there is a public servant, if there is public in official capacity, if he has committed any offense, for whatever conduct of the trial, permission of the government or superior officer is required. This is the sine qua non. And at this juncture, if the alteration or addition in charge is taken place, then necessary permission from the or sanction from the appropriate government is required. So it means that if the altered charge required a government sanction, the trial must be stayed until the sanction is obtained. If the sanction for the same facts was already granted earlier, fresh sanction is not required. Now, section 240 of the BNSS provides recall and re-examination of witnesses. This section ensures fairness after a charge is altered by allowing both the sides to revisit witness testimony. Witnesses are called again or in accordance with the altered or added its concern. Even a new witnesses also called, even earlier witnesses also again recalled and re-examined. It means that after an alteration or addition of a charge, both prosecution as well as accused may recall any previously examined witness for further cross-examination, even recalled for the re-examination of such witnesses, even can call the additional witnesses if needed, but subject to the so-called alteration, so-called addition. The purpose behind the recalling the witnesses or additional witnesses are called to examine, the purpose is to ensure the accused is not taken by surprise. So, therefore, it is allowed to fresh questions relevant to new change, maintaining the right to a fair trial. Now, question is whether additional examination is required or not. Asking for taking additional witnesses examination sometimes may cause the delay. So it is court's discretion. The court decide whether additional examination is required. And the purpose of this provision is to ensure balance between preventing delay and protecting the fairness. At one side, calling again and again may cause delay, and other side, if it is not called, the fairness become compromised. And it is the founding principle of law. Fair hearing is the founding principle. So both the things are looked wisely, and court you exercise its discretionary power and accordingly court direct. Now, section 239 to 240, these provisions has conceptual importance. These provisions ensure flexibility, that the criminal proceedings often reveal new fact mid-trial. These sections allow court to modify and charges accordingly. Eventually, during course of trial, if something new things is appeared, does it mean again new proceeding is to be started? No. Same proceeding, through same trial, the whatever new changes came is to be addressed, and accordingly a unique and a comprehensive trial must go. The purpose behind recalling and additional witnesses is to protect the accused. Because of altered charges, the judge must explain to the accused, adequate time needs to be provided, witnesses needs to be recalled. All are the rights of the accused. Otherwise, there won't be fair trial. And therefore, it supports the justice. Errors in original charges, common in complex cases, do not invalidate the trial unless they cause injustice. Alteration enables correction. So section 239 and 240, 239 alteration and addition of charge, 240 recall of witnesses. Alteration and addition, the court may alter, court may add, court may do all the things required any time before the pronouncement of the judgment, and must explain to the accused, and may order for even new trial sometime. Even trial can be adjourned. If there is a sanction of government is required, if the accusations or charges made against the public official, if it is already given, no need, then it is not obtained. If it is required, then it is taken. So far as the recall of witnesses is concerned, after alteration, both the sides may, prosecution side or defense side, accused side, may recall the witnesses, may re-examine. Even new or additional witnesses can be called and examined. The ultimate purpose of section 240 is to ensure fairness, that one shall not condemn being unheard, maybe prosecution or of the accused side. Now we are proceeding towards section 241 to 247, joinder of charges. The Bharatiya Nagrik Suraksha Sanhita allows in certain situation multiple offenses or multiple accused persons be tried together. Section 241 to 247 lays down legal framework for when and under what circumstances how such a joinder is permissible. This provision balances the judicial efficiency with the accused right to a fair trial. So section 241 to 247 provides a mechanism what kind of persons are joined together, what kind of multiple offenses can be tried together. These two things are addressed under the head of joinder of charges. So here offenses can be tried together, persons being accused can be tried together. What kind of offenses tried together? What kind of persons being accused tried together? The general rule is that each and every distinct offense must have a separate and independent charge, and a separate trial should be, unless otherwise permitted. But there is exception to the rule. The general law is separate charge, separate trial for each and every distinct offense. But this rule has exception on the accused request. If the accused applies in writing to the magistrate that these kind of offenses may try, or these kind of charges may try together, provided that such joinder of charges shall not prejudice the accused, though there is a request on the part of the accused. It means that if suppose one person has committed numerous offense independently, got my point? One person, one accused has committed offenses differently. One offense has no nexus with other offense. Got my point? At one place he committed theft, other place he committed assault, third place he committed grievous assault. है ना? So at this juncture, whether independent three trial at three places should be taken place by framing separate charge, yes or no? है ना सर? असंच पाहिजे ना? चोरीच्या ठिकाणी theft committed, then trial for theft should be independent. So this is the law says that for each distinct offense there shall be separate charge, separate trial. What is wrong? Nothing is wrong. But the nicety of the provision of the law is that if accused is requesting to the magistrate, provided that the offense should be committed within the territorial limit of the jurisdiction of the same court, then the accused can request, sir, it is my humble request to the honorable magistrate that these are the three distinct offense, charges are made distinctly, but it is my request these offenses are to be tried together. Why should I come again and again? The purpose behind this provision is to ensure clarity of prosecution while avoiding confusion between unrelated offenses. Whether the request made by the accused is sent to the prosecution and say from the prosecution is taken, Mr. Prosecution, this is the application. There are three kind of offenses committed independently, charge independent, trial is independent, but now he made request, he asked for joinder. What to do? If there is no hardship on the part of the prosecution and to avoid the confusion, the court can ask for separate trial. If there is no confusion, then trial should go comprehensively. This is the purpose. Why 3 cases, 3 magistrate, 3 court for the same purpose, same person is to be engaged. Got my point? If there is confusion, then there shall be trial separate. If there is no confusion, what is wrong? It is true. There are certain kind of offense, though it look independent, but it's part of the offense. Sometime we will come. That does not mean, that does not mean distinct, does not mean is independent purely. We now we will proceed. Then you will get more clarification. But ठीक. Offenses of the same kind within 1 year म्हणजे काय? साम्य असलेले विविध गुन्हे एका वर्षात जर केलेले असतील तर काय? आता साम्य असलेले गुन्हे कोणते? BNS has been classified. BNS ची किती ऑफेन्सेस क्लासिफाय? ऑफेन्स अगेन्स्ट ह्युमन बॉडी, ऑफेन्स अगेन्स्ट प्रॉपर्टी, ऑफेन्स अगेन्स्ट माइंड, ऑफेन्स अगेन्स्ट रेप्युटेशन दिलेलं आहे ना. तर 242 सेक्शन काय म्हणतंय? दिस अलाउज सर्टन ग्रुपिंग ऑफ सिमिलर ऑफेन्सेस. काही कसे आहेत? ॲग्रिव्हेटेड फॉर्म मधले आहेत, सेक्शुअल ऑफेन्सेस म्हणजे काय? त्याचा एक ग्रुप आहे. When the accused commit offenses of the same kind within a period not exceeding 1 year, एका वर्षात काही विशिष्ट प्रकारचे केलेले ऑफेन्स किती? 3. किती? Such offenses may be charged and tried. कोणते ऑफेन्सेस पाहिजेत? सेम काइंड. खाडगाव रोडला एक चोरी केली, आंबा हनुमान पशी एक चोरी केली, राजीव गांधी चौकात एक केली. ज्युरिडिक्शन समजा एकाच न्यायालयाला आहे आणि एका वर्षात केलेली आहे. एका व्यक्तीने केलेली आहे, एका वर्षात केलेली आहे, एका कार्यक्षेत्रात केलेले आहे, 3 केलेले आहेत. सेम काइंड म्हणजे काय? ऑफेन्सेस कन्सिडर्ड ऑफ सेम काइंड म्हणजे काय? त्या ऑफेन्सची डेफिनेशन जर पाहिलो तर त्याचे कॅरेक्टरिस्टिक जवळपास सारखी. आणि कायदा तोच आहे, कायद्यातील तरतूद पण तीच आहे. 303 BNS काय आहे? थेफ्ट ना. तर 303 BNS, 303 BNS, 303 BNS. एका ठिकाणाहून मोबाईल घेतला, एका ठिकाणाहून चार्जर घेतलं है ना, एका ठिकाणाहून अजून काहीतरी तसंच घेतलं, त्याच्याशी उपयोगात असणार पॉवर बँक घेतली, है की नाही? आणि द व्हॅल्यू ऑफ द सब्जेक्ट मॅटर इज ऑलमोस्ट नियर ऑर मोर तेच आहे. आणि हे एका वर्षात कमिट केलेले ऑफेन्सेस आहेत. मला सांगा, ह्या 3 ऑफेन्सेसची 3 स्वतंत्र चार्ज फ्रेम करणं, 3 स्वतंत्र ट्रायल चालवणं, हे हार्डशिप नाही का? कदाचित इन्व्हेस्टिगेशन ऑफिसरही तोच, प्रॉसिक्युशनही, मॅजिस्ट्रेटही. काय चेंज झालंय? प्लेस, टाइम and victim. Offenses are considered as same if the offense has common characteristic, the legal provision and the law is, if it is one and the same, it is said to be same kind of offense. Section 243 provides trial of multiple offenses in one series of acts. तुम्ही म्हणलेलं इथं लक्ष देणं गरजेचं आहे. 243 इथून पुढचे सगळेच प्रोव्हिजन गंभीर आहेत, किचकट वाटतात. ट्रायल ऑफ मल्टिपल ऑफेन्सेस इन वन सिरीज ऑफ ऍक्ट्स. इट मीन दिस कवर्स ए सिच्युएशन वेअर मल्टिपल ऑफेन्सेस अराइज फ्रॉम ए कनेक्टेड चेन ऑफ इव्हेंट्स. कनेक्टेड चेन ऑफ इव्हेंट म्हणजे काय? ती कृती करायची असेल तर ही करावी लागते, ती पण कृती गुन्हा आहे आणि ही पण कृती गुन्हा आहे. है ना. Preparation is offense, attempt is offense, commission is offense. Preparation is independent provision, attempt is independent provision, commission is independent provision. आता attempt to commit suicide is offensive act. Abatement to commit committing murder is offense. Abatement to commit murder is offense, है ना. So whenever issue of joint liability arise, joint liability when arise, there are minimal 2 persons required. So similarly, for committing a particular offense, there is series of actions, and some of the actions are independent offense. So when trial of multiple offenses in series of acts can be possible in one trial. When applicable, when the accused commits several offenses as part of same transaction or connected series of acts. जेव्हा आरोपी हा विविध स्वरूपाचे गुन्हे करतो आणि हे गुन्हे एका चेनचा भाग आहे, पार्टचा भाग आहे. मर्डर करायचं रिव्हॉल्वर न केला, कीपिंग रिव्हॉल्वर इज अन ऑफेन्सिव्ह ऍक्ट, येस ऑर नो. आर्म ऍक्ट खाली सिरियल किलर इज अदर आस्पेक्ट. ते अगोदरच्या प्रोव्हिजन मध्ये गेलं, एका वर्षात 3 ऑफेन्स करणे. हे कसं आहे, तिथं पोहोचण्यासाठी मला हे ऑफेन्स करून जावे लागतात, मग तो ऑफेन्स होतो. मल्टिपल ऑफेन्स, हां, विविध ऑफेन्सेस करतो. असं एखादी गुन्हा करायचा आहे, ते करण्यासाठी त्यानं त्याही कायद्याचा भंग करतं, ह्याही कायद्याचा भंग करतं, ह्याही कायद्याचा भंग करतं, तेव्हा तो ऑफेन्स होतो. एक ऑफेन्स करण्यासाठी 2-3 ऑफेन्सेस तुम्हाला करावे लागतात, अशी परिस्थिती आहे. Such offenses may be charged and tried together if they differ in a nature. जरी ते वेगवेगळे जरी असले तरी. So what is rational for trying together of such offenses? The purpose is to ensure efficient trials and prevent fragmentation of cases that are factually interlinked. एक प्रकरण दुसऱ्या प्रकरणाला लिंक आहे, तर त्याची कशाला सेपरेट ट्रायल करायची, काय गरज आहे. Sometime charging separately and trying separately cause hardship, not to the accused, to the prosecution, not to the prosecution, to the even trial court, even to the witnesses and whosoever being part and parcel of the criminal case. Section 244 pertaining to the doubtful offense, alternative charges. This section deals with the situation when it is unclear which of several offenses was committed. नेमके किती गुन्हे केलेले याचा ताळमेळ लागत नाही, अनक्लिअर आहे. अशा वेळेस काय करायचं. when a single set of facts may constitute multiple possible offenses, then alternative charges may be framed. काय म्हणताय सर, हे लईच महत्वाचं आहे. When a single set of facts may constitute multiple possible offenses, alternative charges may be framed. 2. Accused may be charged with all such offenses or any of them and tried accordingly. 3. If evidence shows that one offense not originally charged was committed, the court may convict for that offense. अब नहीं समझ लेना? नहीं. When a single set of facts म्हणजे एक सेट आहे, त्याच्यामध्ये वेगवेगळे फॅक्ट्स आहेत आणि हे मल्टिपल ऑफेन्स कमिट केलेलं निर्धारित होतं. अनेक गुन्हे त्याच्यापासून उघड होतात. आता एखाद्या घरी चोरी झाली, चोरी इज द ऑफेन्स, हा पहिला गुन्हा झाला. तो चोरी करण्यासाठी त्याने ती खिडकी तोडली. ते लर्किंग, हाऊस ब्रेकिंग शब्दप्रयोग आहे ना, तो एक ऑफेन्सच आहे ना, है ना. आणि ते तोडण्यासाठी त्यांना तिथलं ते ब्रेक केलं. अजून आलंच की हा. बर, चोरी करण्यासाठी एका माणसाला कोंडून ठेवलं, ते बी इंडिपेंडेंट ऑफेन्स झालाच की. मग ही चोरी करण्यासाठी याने नेमकी किती किती ऑफेन्स केलेत. मल्टिपल ऑफेन्स इज कमिटेड. वन सेट ऑफ ऑफेन्स, वन सेट ऑफ फॅक्ट, काहीतरी सेट ऑफ फॅक्ट काय, खाडगाव रोड, रात्रीचे 12, हे कोणते सेट ऑफ फॅक्ट आहेत, है ना. वस्तूची किंमत सेट ऑफ फॅक्ट आहे, वेळ सेट ऑफ फॅक्ट आहे, दिवस सेट ऑफ फॅक्ट आहे, डे नाईट, है ना. घर कोणाचं, गल्ली कोणती, सेट ऑफ फॅक्ट आहे. कोणाच्या कार्यक्षेत्राअंतर्गत सेट ऑफ फॅक्ट आहे, पार्ट ऑफ फॅक्ट आहे, आणि सगळं मिळून सेट ऑफ फॅक्ट आहे. या सगळ्या सेट ऑफ फॅक्ट मधून जर बाहेर जर काढलं, ही हॅज कमिटेड मल्टिपल ऑफेन्स. एक तर चोरी केली, नुसती चोरी केली नाही, हाऊस ब्रेकिंग केली, ब्रेकिंग नाही, त्यांना रॉंगफुली कन्फाईन नाही केलं, अशी परिस्थिती असेल तर काय करावं. देन द अक्यूज मे बी चार्ज. आणि नुसतं एवढंच नाही, ह्याच्यातून हे समजत नाही नेमकं याने अजून काय काय केलंय, नेमकं कोणतं कोणतं केलं ऑफेन्स. The accused may be charged with all such offense or any of them and tried accordingly. ज्याचे ज्याचे एव्हिडन्सेस रेकॉर्डवर येतात त्याचे त्याचे चार्जेस फ्रेम करणे. व्हॉट सेक्शन 244 सेज. जे रेकॉर्डवर येत नाही त्याच्याबद्दल काही करायचं नाही. इव्हेंच्युअली आफ्टर फ्रेमिंग द चार्ज, whatever new things will come during course of trial, then charge can be altered, charge can be added. हो ना, त्याचे तर प्रोव्हिजन आहे आपल्याकडे. फक्त 244 एवढंच म्हणणं आहे की बाबा ऑफेन्स हा डाऊटफुल आहे किंवा किती ऑफेन्स केलेत याबद्दल थोडं शंका कुशंका आहे. तर तुमच्याकडे जे जे एव्हिडन्स येतात आणि व्हॉट काइंड ऑफ एव्हिडन्स मेड आउट द ऑफेन्स, यू फ्रेम द चार्ज. व्हॉट इज
उदाहरण सांगतो. तुमच्या घरची कथा आहे, ती घडलेली घटना. चोर आला तुमच्या घरी अमृतपूरच्या, आमचं कुलूप तोडलं, ते मधून लावलेलं होतं, त्याला दारच काढता आलं नाही. ते कुलूप गेलं घेऊन दुसऱ्याचं तोडलं, ते कुलूप तिथं नेऊन टाकलं, त्याचे पैसे घेतले देवापूरचे, ते काही थोडेफार. तिसऱ्या ठिकाणी गेलं, तिथेही चोरी केली, तिथले बरेच दागिने बिगिने. आता हे
एका सेटअप बरोबर आहे.
सेटअप
नाही नाही, कायद्यासाठी अक्यूज आहे की अक्यूज साठी कायदा आहे?
Right. आता victim आम्ही
नाही नाही नाही, या कायद्याप्रमाणे त्यानं एका दिवसाला एकच चोरी करावी असं कसं होईल?
victim आम्ही 3 जण होतो. पण तो चोर अनेक होते ते.
गावाकडं कसं होतं सर, आगल्याची चौकी आली की 5-7 जण पुढं
हा.
जातात.
ते आमोशच असते ना. Section 245, conviction for minor offences. Section 245 allow a person to be convicted for a minor offense even if they were charged with a major offenses. म्हणजे गुन्हा लावताना कोणता लावला? चार्ज करताना ग्रीवियस हर्ट. ट्रायल मधून काय निघालं? हर्ट. मग त्याला शिक्षा कशाची द्यायला पाहिजेत? त्याला चार्ज जरी मोठ्या ऑफेन्सचा जरी लावला तर ही इज कन्व्हिक्टेड फॉर मायनर ऑफेन्स. असं नाही की चार्ज, आता अग्रिवेटेड फॉर्म आहेत ना सर, थेफ्टचा अग्रिवेटेड फॉर्म डकैती आहे.
Yes.
नाही नाही, अगोदर चार्ज कोणता लावला होता? डकैतीचा. 5 माणसं होते का? मग नाही निघाले. 2 होते का? ते म्हणजे रॉबरी बी नाही, डकैती तर नाही, रॉबरी बी नाही, मग निघालं काय? एकानंच केलेलं दिसलं. मग त्याला शिक्षा कशाची? डकैतीची द्यायची का? चार्ज डकैतीचा होता किंवा रॉबरीचा होता, पण रॉबरी होण्यासाठी काही कंडिशन आहेत ना, त्या जर ट्रायलमध्ये जर पुढे नाही आल्या तर शिक्षा मग काय? त्याला काय डकैतीची बी शिक्षा द्यायची नाही, त्याला रॉबरीची बी द्यायची नाही, मग त्याला काही थेफ्टची देऊ नये काय? डकैती होण्यासाठी थेफ्ट लागते, असं आहे हो हे. रॉबरी होण्यासाठी थेफ्ट लागते का नाही? मग मोठा नाही तर नाही, छोट्यात बसला का अडकला का यू पनिश, कन्विक्ट. असं. व्हॉट इज एसन्स? इफ द अक्यूज इज चार्ज with a major offense but the evidence proved a commission of minor offense, then conviction for the minor offense is permitted by this provision to the trial court. Under section 245, trial court can convict for minor offense if it is proved, though charge is framed for major offense. So fine, sir. The purpose is there shall not be acquittal, to prevent the acquittal solely because the prosecution overstated the gravity of the offense in the charge. FIR लावला, इन्व्हेस्टिगेशन ऑफिसरने बरंच काही रेकॉर्डवर आणलं नको ते, ट्रायल कोर्टाने त्यावेळेला चार्ज फ्रेम केला, पण आता काय निघालं? खोदा पहाड निकला. हा, तसं होतंय असं. डोंगर खोदला, उंदीर निघाला, डोंगर पोखरून उंदीर निघाला, उंदीर काढला. सेक्शन 246, पर्सन्स चार्ज जॉईंटली. कोणासोबत जॉईंट चार्ज करता येतो. दिस सेक्शन रेग्युलेट when multiple accused may be tried together. किती आरोपी एका गुन्ह्यामध्ये, विविध गुन्ह्यामध्ये एकत्रित चार्ज केल्या जाऊ शकतात. विविध आरोपी एका ठिकाणी चार्ज कोणत्या परिस्थितीत केल्या जाऊ शकतात असं म्हणायचं आहे ना. विविध व्यक्ती एका गुन्ह्यात चार्ज केव्हा केल्या जाऊ शकतात? 246. when trial is joint. The trial is joint when numerous person may be charged and tried together if the accused of they are all whosoever, one, not one, 2, 3, 4, 5, 6, 7, whatever the figure of the person, multiple person, numerous person, they can be charged together, tried together, if they have committed same offense in same transaction. Even sometimes they have committed different offenses but committed for same transaction. It means an offense and its abatement. One has committed, other has abated. An offense one has committed, other one has attempted, or one has conspired to commit relating to the commission of same offense by giving the aid. म्हणजे गुन्हा करण्याच्या पूर्व मदत करणे, गुन्हा करताना मदत करणे, गुन्हा केल्यानंतर लपवलपी करण्यासाठी मदत करणे, है ना. दे somewhere they aid, because of their aid the offense is committed. If they were not present, then there won't be commission of offense. दरोडा टाकायचा आहे, एक जण बँकेच्या तिकडल्या साईडला, एक जण इकडल्या साईडला, एक जण पोलिसांच्या गाडीवर हे ठेवतं. ते वाळूची तस्करी करणारे काय करतात, रेव्हेन्यू ऑफिसरच्या गाडीसोबतच्या मागच एक जण मोटरसायकलवर फिरतो सांगत. रेव्हेन्यू ऑफिसरच्या गाडीला खालून काहीतरी लावायचं, GPS लोकेट करण्यासाठी. हे काय आहे तर फॉलो करणं, दिशादर्शक ठरणं, मॅपिंग करून देणं, वस्तू उपयोगाच्या आणून देणं. इंडिव्हिज्युअल ऑफेन्सेस दॅट आर पार्ट ऑफ ए कनेक्टेड सिरीज ऑफ फॅक्ट्स. वेगवेगळे, इथं एक ऑफेन्स केला, याचा परिणाम तिथं ते झाला, तिथं ते झालं, तिथं ते झालं, ह्या ऑफेन्समुळे हे झालं, त्या ऑफेन्समुळे ते झालं, त्या ऑफेन्स, आणि शेवटी त्यांना असं सिरीज ऑफ ऍक्ट, सिरीज ऑफ ट्रान्झॅक्शन. एक ऑफेन्स करण्यासाठी वेगवेगळे लोक काम करतात. असं सेम ऑफेन्स कमिटेड in the same transaction, different offenses committed in the same transaction. Offense of abatement, offense of conspiracy, offense ते काय attempt, preparation, commission. प्रिपरेशनच्या स्टेजला एक जण काम करतंय, अटेम्प्टच्या स्टेजला एक जण काम करतंय, कमिशनच्या स्टेजला एक जण काम करतंय. असं द रिझन फॉर जॉईंट ट्रायल इज टू प्रमोट judicial efficiency while preventing inconsistent verdict. जर समजा प्रिपरेशनच्या स्टेजला जर एखादी जर ॲक्विट जर झाला तर अटेम्प्ट मध्ये काय होईल? मग बुडात चोरीच सिद्ध नाही झाली तर दरोड्याचा काय संबंध आहे की नाही? आणि म्हणून दरोड्यातला गुन्हेगार निर्दोष सुटू नये, केवळ थेफ्टचा गुन्हेगार निर्दोष झाला म्हणून. कारण थेफ्ट अँड डकैती इज पार्ट ऑफ सेम ट्रान्झॅक्शन, सिरीज ऑफ ऍक्ट. नाहीतर त्यांना एक व्हर्डिक्ट देईल, त्यांना एक व्हर्डिक्ट देईल, त्या न्यायालयाचं वेगळंच राहील, है ना. एका ठिकाणी एका कोर्टामध्ये अबेटमेंटचं मॅटर चाललंय, एका ठिकाणी कमिशनचं चाललंय. कमिशनचा जर निर्दोष झाला तर अबेटमेंटवाला काय होईल? आणि ते जर दोघं एकत्रित चालले तर एक तर दोघंही निर्दोष होतील, नाही तर दोघंही मध्ये जातील. एकटा निर्दोष सुटणार नाही, एकटा सेक्शन 247 सर जवळ आलो बघा. Section 247, withdrawal of charges. This section applies when a person faces multiple charges in one case. एका केस मध्ये multiple charges. After conviction on one or more charges, The prosecution or complainant may seek to withdraw the remaining charges with the court permission, and the court may allow on its own motion or own stay or withdraw those remaining charges. Once charges withdrawn, the remaining charges are treated as an acquittal for the accused. And therefore, if the original conviction is later set aside, the court can revive and proceed with the withdrawn charges. Such a provision ensures efficient trials by avoiding unnecessary proceedings on lesser charges once a conviction is already secured. So with this word, the notion of charge is almost going to conclude. So separate trial for distinct offence. Each offence is tried separately to ensure clarity and fairness, with opinion for joint trial if no prejudice occurs. So joint trial for a related offence. Sections allows grouping offences of the same kind or related acts for joint trials to streamline legal proceedings. Conviction on alternate charges. Court may convict on charges different from those filed if evidence support the offence proven. And withdrawal of remaining charges. Post conviction, court can approve withdrawal of other charges, treating them as acquittal unless overturned. In this way, the provisions as to the charge from section 234 to 247 is concluded. If anything asked, it may be asked. Thank you. अरे राम काय विचारायचं